Hello, and welcome to the latest webinar from the section of Civil Rights and Social Justice. During the 2017-18 bar year, our goal is to rapidly respond to government actions that may impact civil liberties and civil rights by offering free webinars, commentary, podcasts, social media posts, and other information from subject matter experts. We encourage you to check our section's website, www.americanbar.org/CRSJ, our Facebook page, and our Twitter handle @ABA_CRSJ for news and information and replays of our great programming. And if you like our work, we invite you to become a member of the section and collaborate with us on projects you want to develop and offer it to our members and the general public. Today's program, entitled Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act and State Advocacy, is an in-depth discussion among experts of the newly adopted UGCOPAA and how it can be used as part of state-level advocacy. We're thrilled that we were able to coordinate these excellent speakers to provide you with another great program. While you're watching today, please feel free to ask questions to our panelists during the program by writing them in the drop-down questions option on your panel. We'll be reviewing the questions so that we can answer them at the end of our program. Our moderator today is David English, who is the chair of the drafting committee for the UGCOPAA, a professor of law at the University of Missouri, and the chair-elect of the ABA section of Real Property, Trust, and Estate Law. Professor?
Thank you very much for assisting in getting this program organized. I will be joined by three panelists today. Nina Kohn is many things, but among her accomplishments, she's a professor of law at Syracuse University, where she's also assistant dean. She was the reporter for the Uniform Act with a very long name that we'll be hearing more about during this webinar. And she has also held leadership positions in the section of Civil Rights and Social Justice, and also in the Real Property, Trust, and Estate Law section. We will also be joined by Diana Noel, who is a senior legislative representative with AARP. She's located near DC, but she does a lot of travel because her main role is to provide technical assistance to the states in getting laws enacted. So unlike our typical what is the law talk, this presentation not only goes through what the law is, but tells you how to get the law enacted in your particular state. And that's what Diana does on a daily basis. The act we're going to talk about today is the Uniform Law. The Uniform Law has a staff in Chicago, which is highly talented in helping states get laws enacted. And our final speaker will be Ben Orzeske, and Ben is the chief counsel for the Uniform Law Commission and has also held leadership positions within the American Bar Association. So let's go ahead and get started. We have beautiful photographs of all of us on the next panel, although this is the first ABA webinar, at least I've done, where we're all on the screen together. So what we're going to start off on is a little background on what is the Uniform Law Commission, what are these strange things called uniform laws, and a little bit of history on guardianship. So Uniform Law Commission is an organization formed by the states, but it's not state government. It's an independent, not-for-profit organization. And each state appoints commissioners who are attorneys who are not paid, who volunteer to draft legislation. It's great that the term uniform law is used. It's an aspiration that states will enact the law uniformly. That happens sometimes, but in reality, most often the acts are really model acts, which are templates for states to adapt to their particular circumstance. Let's go ahead and move to the next slide. Guardianship law goes back at least at the uniform law level, to 1969. The Uniform Probate Code, which has been enacted in full in about 20 states, but it's been enacted in pieces in all states to varying degrees, had an article, Article 5, that dealt with guardianship issues. And UGCOPAA, which is the acronym for the act we're going to talk about today, is directly traceable to the 1969 enactment. There was a major revision of the guardianship law in 1982. And at that time, in addition to being part of the UPC, it was made available in what's called freestanding form. That means the state didn't have to enact the whole UPC. It could enact guardianship separately as a piece, and that was called Uniform Guardianship and Protective Proceedings Act. The 2017 Act that we're going to be talking about today is a successor to the 1997 revision. However, there's some important related uniform acts that had a major influence on the drafting process of what we're talking about today. These include the Durable Power of Attorney Act from 1979, which has been enacted in either pure or modified form in just about all states. There was a major revision of that Durable Power of Attorney Act in 2006. That's the Uniform Power of Attorney Act. And Ben can give us the exact number, but I think it's approaching 20 enactments. Somewhere.
25 now.
25. See, so even I'm a little bit behind here. And then another act, and a final one I'll mention here, which is not on the slide, but in 2007, we completed, the Uniform Law Commission completed the Uniform Adult Guardianship Jurisdiction Act. I'm leaving out a few of the words, which deals with situations where you're moving a guardianship from state to state. So there's a lot of activity, other uniform laws that led up to, that is background for the 2017 UGCOPAA, if I can say the acronym. So next slide. So we have this huge history of law reform. We also have a long history of studies of guardianship. And so we have, in the 1980s, we had what was called the Wingspread Report, which was written by the ABA, recommending revisions of guardianship practice and law. We had what's called the Wingspan Report in 2001, which was a second effort to get a group of experts together and talk about revising guardianship law and practice. And then finally, in 2011, we have the third National Guardianship Summit, where 100 experts, both individuals as well as representatives of the wide array of groups that you can see on the slide on the screen, got together and spent 3 days or so hashing out guardianship law and practice issues. And the road to UGCOPAA is directly traceable to this 2011 conference, which was held at the University of Utah. Next slide. So we have this conference in late 2011. What happens at these conferences? You're locked in a room for 3 days and come up with a set of recommendations. And then the editors, and we owe great thanks to Sally Hermy, who was formerly at AARP, now retired, and to Erica Wood of the ABA Commission on Law and Aging for taking the summit recommendations and editing them and converting them into a solid 8-page document. So that was 2012. Over the next year or so, these Recommendations and standards were all reviewed. And then I had the honor of working with Linda Whitten of Valparaiso University, and who was the reporter for the Power of Attorney Act, to pull out of these recommendations and summits, excuse me, a list of items that required or made sense that there be a statutory implementation. And so we prepared this list of recommended statutory issues, presented it to the Uniform Law Commission leadership, and so in 2014, a drafting committee was appointed. I was the chair of the drafting committee, so we can kind of move on to the next slide, if it's working. And its role of chair is to help really do several things, but one is to try to get as much input as possible. So the third guardianship summit at the University of Utah, the attendees included representatives from all the different groups on the screen. Those same groups were all represented, plus many other groups, on the drafting committee. So even though the statute is technically passed by commissioners or appointed by the governors of each state, a major effort is made to get input from as many different groups as possible, with the idea that the final result would be a consensus product. So we typically would have more than 30 different people in the room at our drafting sessions, but of course, many people also made contributions by email and so on. Next slide. The predecessor to UGCOPAA is the 1997 revision of the Uniform Guardianship and Protective Proceedings Act. The term protective proceedings, if you have spent most of your life in UPC land, which I have, is very understandable. If you're not from a UPC state, it's not immediately apparent. And so 2017 the act has a new title, one, to make it clearer, but second, and I think even more important, is to emphasize alternatives to guardianship or conservatorship, one of which under the act is the protective arrangement. That protective arrangement was in the 97 Act, but it was kind of buried, and many practitioners were not aware of it. And I think that concludes at least my initial comments. And Diana, I believe it's your turn.
Yes. Okay, so David gave us a nice little overview of how the Act came to be. So I'm going to step back a little bit and just tell you and talk to you a little bit about why. Like, why is this even necessary? Why is guardianship reform even necessary? You can go ahead to the next slide. So David mentioned this and he touched upon this a little bit, but most states haven't had a major revision of their guardianship laws in over 20 years. So, and you see the 16 states haven't even revised them since the Reagan administration or earlier. Think about, and just take a minute and think about all the changes that's happened in the world since the Reagan administration or even before then. So even David just mentioned his last ABA webinar. He couldn't see all of the panelists on the screen. And now today, guess what? Everyone's on the screen. So that's just a little small example where with the technological changes, just think about how far behind guardianship reform is in states right now. We've all seen the articles. We all know what they're about. We've all read them, and there'll probably be more coming. So, but here's the thing about the articles that you need to pay attention to. They're bringing attention to the issue. They're showing basically that these guardianship laws are pretty much outdated and they're in need of reform. So what they are doing, these articles, they are pointing out a lot of holes in these systems and across states. And what we're seeing across states is that there are some things that could stand for some updating, especially when it comes to abuse and exploitation, because obviously those stories are getting highlighted the most. And lastly, people are living longer. We, again, with the technological changes, we have medical advances, things that are there that are making people live a little bit longer and helping us live full and productive lives. So the system that we currently have is not ready. It's not ready for the amount of people that may be coming its way. So what do we see? We can go to the next slide. What's common across states? So separate from the Uniform Act that we're discussing today, what issues out there have been common that we're seeing across state lines? And none of this, I'm sure, will probably be news to you all, but it may be news if you're in one state and you're thinking, oh my gosh, this is just me. Well, your neighbors are dealing with these things too. So caregiving. People they really want to age in place and live at home. So most of the folks who are caring for them are their family members. Some of these family members are now being appointed as their guardians or conservators. So what does that mean? How do you go from being a daughter or a son or a wife to now being a guardian? And what does that mean? So that's what states are grappling with caregiving. They're grappling with a shortage of guardians. There just aren't enough people who are willing and able to serve in that capacity, which then leads to issues with public guardianship. Some states have some public guardianship issues as far as funding, as far as finding guardians, and just making sure that they have everything that they need as well. And like the articles point out, there's some abuse and exploitation going on in the system, whether it's by private professional guardians or by family members. Either way, there are some things that are happening across the country that's within guardianship. Court monitoring, that too has been something that's been discussed a lot lately across the country. We're seeing trends there. Individual rights has really stepped up. We'll go into a lot more details about how the Act addressed some of these things, but just to know that the baseline is these are all common issues that are happening across states. Alternatives and some other options instead of a full guardianship, that is something that's also common. States are interested in learning more and what does it mean? How does it apply? And the biggie, I think, is the lack of data. It's kind of hard to get funding for public guardianship or for your courts if you don't have the data to show that why you need the funding, especially when you're approaching your state legislature. So, moving on, next slide. So what's trending? Oh, back up a little bit. One more slide, back up. Thank you. So what's trending? In addition to common issues, there are some things we're seeing across the country that are really making this an interesting time in the world of guardianship. The first thing is folks are talking. Like we are here today, and as I understand, there are a lot of you out there looking at the four of us right now, and I appreciate your time being on this call to learn more. But folks are talking about this issue. Another reform trend is just a more person-centered approach of really focusing on the individual and the alternatives. What other options are out there for that individual? More of an individualized system versus a one-size-fits-all. Standards and training for guardians, whether it's private or public guardian or family guardian, people need to know what their roles are and how to do it and do it well in order to serve the individual. Education and outreach. If you have a fantastic system, you have a fantastic training program, and it's out there, but no one knows about it, does it really exist? It's like the tree in the woods. So people are really stepping up their game and letting people know about the training and other services and supports that are available to individuals and to their family members to let them know that things exist, like what exists in my state and where can I find it. At the end of the day, that's what people really want and need. There are a lot of discussion and trends around monitoring reforms that are happening to help prevent abuse and exploitation. And the biggest thing, which I see is awesome and an amazing thing, is that it kind of goes back to the first bullet where people are talking. Well, guess what? They're talking to people they may not have talked to before. I mean, you look at the four of us here, and we're all in 4 different states. We're talking to you who are all over the country as well, and we're having these conversations about one issue, which is guardianship. So this is being replicated in states with a lot more collaboration. There's a lot more discussion across professions. There may not be the normal players that are being a part of these conversations, but one thing you really need to understand about this issue is that this is something that crosses and touches every single branch of government. So every single branch of government, they're waking up and they're realizing, hey, we have a role and we need to get together with people who are experts, who have experienced this, and who may one day need a guardian, and put everyone in the room and talk and discuss. And that's how reforms are really happening, and that's what's going on in states. So now, next slide, back to the Uniform Act. So what I've done is I'm trying, if you have an elevator speech and you have to explain the 180-something pages of this act and all the details to someone, to a legislator or someone who really doesn't know what it's about, here's what I say. I said the act does 3 things. There's a focus on the courts, there's a focus on the guardian, and focus on the individual. Then you can go and have further conversations about each specific aspect of it with the courts, with the guardian, and about the individual. You'll see the bullets on the screen about what each thing goes through. I'm not going to go through them now because Nina's going to she's going to do that following me. But you'll see where there are some places where you really need to know that that's the kind of thing that this act is looking to do. And this is what we're trying to get across, is that there is a focus on all 3 of these aspects that also have to work together. There will be some overlap, and that's fine, because that's exactly how the system should work. So, Nina?
Great. So what I'm going to do now then is give you a deep dive into some of the key provisions in the Act itself. And I want to start off by talking about the language we use. And you might think that this is a rather simple thing, but believe me, it took us many, many meetings just to be able to figure out what we were even talking about. So if you're familiar with older guardianship laws or the 1997 version of the Act, you may be used to seeing terms like alleged incapacitated person or ward or incapacitated person. And the thing about those terms is that they're increasingly seen as stigmatizing and disrespectful of the individual. They were rejected by the National Guardianship Summit. They've been subject of extensive criticism. And so one of the first things the drafting committee had to do was figure out, what do we use? Do we use these terms? Do we come up with some fun-sounding acronym? Do we call these people persons under guardianship? But that was pugs. No one wants to be a dog. What do we do? And after much angst and hair pulling, we came to this odd realization, which is that adults who are subject to guardianship are adults. And we could just say that. And so we did. And so the Act now uses the term adult, or adult subject of a proceeding, adult subject to guardianship or conservatorship. And when we're dealing with a minor, we can say the same thing, a minor. And so we ended up with this remarkably simple solution to what was a vexing problem. And so you'll see that change in terminology. I think it may take a little bit of time to wrap your mind around it, but once you start using it, it actually is really simple. So I want to walk you through some of the key provisions, as I said, One of the really exciting things I think about the Act is the introduction of very clear person-centered decision-making standards for both guardians and conservators. And the goal here is to both improve the experience for the person who's subject to guardianship or conservatorship, but also to make this easier, frankly, on guardians and conservators. Many people really want to do the right thing, but they don't know what they're supposed to do. So can we make it clear to people so they know what to do, so they're not second guessed by family members about whether they're doing the right thing, and so forth. So what decision-making standard did we arrive at? Well, under the Act, guardians are required to make the decision they reasonably believe the adult would make if able, unless doing so would unreasonably harm or endanger the interests of that adult. And figuring out what decision the person would make, the guardian is specifically instructed to consider a series of different things. The adult's previous or current directions, their preferences, their opinions, values, actions, to the extent that the guardian can reasonably ascertain those. So ultimately, what you have there is a requirement that you make the decision that you believe the person would make if they were able to do for themselves, unless that decision will cause substantial harm, and some guidance as to what to look for, and an affirmative duty to look for that evidence. But at the end of the day, there may well be situations in which the guardian cannot figure out what the person would do, or what the person would do would be harmful to the person. And there the guardian is instructed to make the decision that's in the best interest of the adult. There's additional instructions in the Act to help the guardian determine what we mean by best interest and what information they can consider in arriving at that determination. Now, for those of you who are familiar with the Act, you'll know that the Act separates out guardians and conservators. Guardians dealing with the personal affairs of the individual, conservators dealing with the financial affairs. You may well be in a state, I am, which uses the term guardian for both, or you may be in that wonky state that uses the term conservator for both. The Act takes this position, but you can obviously substitute your own language. So let me show you for a moment what the difference is for the decision-making standard for conservators. And what you can see on the screen in front of you is the decision-making standard for conservators. And you can see it's really the parallel decision-making standard as for guardians. What I've done is highlight in red for you the differences. And so what you can see there is that the Act recognizes that the conservator should not make the decision that the individual would make if able, if doing so would fail to preserve the resources needed to maintain the individual's well-being or lifestyle, or otherwise unreasonably harm the individual, right? That may be the reason you put in a conservator in the first place, is that the person is making self-harming decisions. The other difference really here with the decision-making standard for conservators is, again, in looking at when to use the best interest standard, you can use that best interest standard when the decision the individual would have made, if able, would fail to preserve the necessary resources. Let's move on then. And one of the really important parts of this Act is the part of the Act which talks about when you can actually impose guardianship or conservatorship on an individual. And the Act makes it very clear that a court is not authorized to appoint a guardian or to appoint a conservator if the person's needs could be met using less restrictive means, including supported decision-making. And then the Act does something pretty important. It defines supported decision-making. The supported decision-making has been at the tips of people's tongues increasingly, but it's sometimes a bit of a Rorschach test. And so we spent some serious time coming up with a consensus definition of what we meant when we were talking about supported decision-making. So the Act defines supported decision-making as assistance from one or more persons of an individual's choosing in understanding the nature and consequences of potential personal and financial decisions, which enables the individual to make decisions and communicate a decision once made if consistent, with the individual's wishes, right? So we have there that it's assistance from someone the person chooses in helping make decisions and helping communicate decisions consistent with their wishes. And this is really important for states which are grappling with what role does supported decision-making play vis-a-vis guardianship. And it provides a really clear instruction as to what the relationship between those two systems is, right? That if supported decision-making is in fact meeting the person's needs, then there isn't the need for a guardianship or conservatorship. If it is not, then there may be a need for a guardianship or conservatorship. Now, then it becomes simply an evidentiary issue as to whether this arrangement is meeting the individual's needs. One of the important parts of the Act is expanding the procedural rights for individuals in the system. And that includes both those who are alleged to need a guardian or conservator and those for whom a guardian or conservator is appointed. So there's a lot of words on the screen right now. My apologies for that. But I wanted to just highlight for you all some of the key procedural protections for individuals alleged to need a guardian or conservator. The Act narrows the exception to the general rule that the respondent must be present at the hearing. So very limited reasons why a hearing can proceed without the respondent present. The Act requires that explicit findings be made before certain fundamental rights are removed. That includes the right to marry or the right to vote. So absence an explicit court finding the person lacks the ability to exercise the right, the person retains that right. The Act precludes appointment of a guardian for an adult by a will or a writing without prior judicial approval. The previous version of this Act had this sort of, for lack of a better word, archaic provision that allowed you to appoint a guardian or conservator for your spouse. And as much as some of us might wish to do that, it didn't really comport with people's sense of constitutional rights or due process. And then the Act also requires the attorney representing a respondent to maintain a traditional attorney-client relationship with that individual, pointing out that the role of a guardian ad litem, for example, is not consistent with the role of an attorney for a respondent who is representing that person's wishes. Then when we flip over to procedural rights post-appointment of a guardian or conservator, there's some that are worth pointing out there as well. There is a requirement of plain language notice of key rights to the individual when a guardian or conservator is appointed. There's provisions added that a person has a right to retain an attorney, that may be at their own expense, to seek restoration of rights. There had been some confusion whether a person could retain an attorney to seek restoration of rights, and we clarify that. It limits the guardian or conservator's abilities to charge fees to oppose restoration of rights. You can see how problematic that would be, right? In that the guardian or conservator may have a financial incentive to continue the relationship, and so a limitation on their ability to, in addition, charge the person for that. And then the Act also creates some automatic triggers for reconsideration of the appointment, recognizing that there may be times where guardianship or conservatorship was appropriate when done, but the person's support system may have changed or their needs may have changed, and that relationship may no longer be necessary. Now, we're not going to have an opportunity to go through all the specific rights in the Act, but here's one I wanted to highlight for you. As many of you know, there has been a real push among family advocates about making sure that individuals subject to guardianship and conservatorship aren't isolated from family members, and concerns that misguided or malicious appointees may isolate the individual and prevent important relationships. And so the Act specifically addresses this. important issue. And it provides that guardians for adults may not restrict the ability of the adult to communicate with or visit or interact with others without either a specific court order or a protective arrangement in place, right, like a TRO, or good cause to believe that that restriction is necessary because the interaction between this person to be restricted and the individual it creates a risk of substantial harm. And then if the guardian goes ahead and does restrict a visitor for that good cause reason, there's a very short time limit for how long that can be without court approval. 7 days if the restriction is restricting a family member or someone with whom the individual subject to guardianship had a pre-existing social relationship. 60 days in all other cases. So you can't have an indefinite restriction without court's approval, even for that non-family member. Okay, so this is not a font problem. This is just me wanting to emphasize something. One thing that's quite notable about this act and what makes it long, but highly satisfying, can we say, is that the act creates a specific avenue for limited court orders, right? So if we go back to the original discussion we were having of the fact that guardianship or conservatorship is not appropriate if a less restrictive alternative would meet the person's needs, well, then there's really a potential role for less restrictive alternatives that meet the individual's needs. And the Act creates an Article 5, which provides specifically for limited court orders instead of guardianship or conservatorship. Maybe you need permission for treatment of an acute medical condition. You may not need a full guardianship. You may just need to address this one issue. There may be a power of attorney that addresses almost everything that the person needs, but there's one power that's missing, and you're seeking court approval for that. And so what the Act does is it creates this opportunity for the limited court order in a very explicit way. And then the final thing I just wanted to talk about is sort of a big picture point, but I think it's important. One thing we really tried to do, I think it's fair to say, in this Act was think not simply about rules, but about systems. Because the reality is that telling people what to do doesn't necessarily change behavior, especially if there's a strong incentive not to do that, right? Or the person you're telling is, let's say, a judge, right? How do you give teeth to that? And so what we tried to do was create systems that work for people to do the right thing in the first place. So for example, we tried to make it easier for petitioners to seek limited orders as opposed to full ones by creating, for example, forms in the Act that could be used for that purpose. We tried to make it somewhat harder to do things that we think are more problematic. So requiring, for example, petitioners to justify at greater length why they're seeking a plenary or full guardianship instead of a limited one. And then we've also tried in this Act to leverage interested persons to help the court system monitor the relationships. So we give in the Act the court order states who gets notice of certain key events in the individual's life, like a change in residence, for example. And there's a default list of people who the court should give that right to, absent of finding that they should not get that notice. And the idea there is that many people are in fact quite interested in the welfare of the person subject to guardianship or conservatorship. We know that courts have limited resources to monitor this, and we may be able to provide superior monitoring by allowing other people notice of these key events, so you have an additional eyes and ears in there for the court. So those are the key provisions I wanted to highlight. Just note that this is not an exclusive, this is not all the provisions, but just some of the highlights. And I want to turn things now over to Ben to talk about advocating for the act in your state.
Great. Thank you very much, Nina. Appreciate it. We, as David said at the beginning of the presentation, the Uniform Law Commission is made up of these volunteer commissioners who are attorneys from all the states, and they do a great job with drafting our acts, but we have a legislative staff to make sure that they don't just sit on a shelf. We're very proud of this new Guardianship Act, and we think it represents a huge leap forward compared to many existing state laws. So how do we now actually get it implemented, put it into place? So can we see the next slide, please? All right, so there's a need for reform. This kind of hard to read map, what we're trying to show here is when was the last major revision of the guardianship statute in each state. Many of them, it dates back well into the last century, and there have been huge leaps forward in the law that somehow are not getting implemented. Inertia takes hold. Courts are used to certain systems; they don't necessarily like change, and so the old laws operate, and people get used to the old procedures. And until we can come in and kind of implement the new laws, things won't change. The states that have a stripe going through them, or a series of stripes, have some version of our old Uniform Act on which this law is based, either the 97 or the 82 Act. And some other states that don't have stripes also have pieces of those acts. So it may be that much of what's in the new Uniform Act is already familiar to the courts and practitioners in your state. In other states, it's not the case. They have something completely non-uniform, and we need to try to educate the participants about the new Uniform Act. You can see the states that are tinted in green are already considering a version of our Uniform Act. There was a bill that was introduced in New Mexico that was stalled earlier this year because of financial issues, but it was implemented in part with a commitment to come back and try to implement the rest of it next year if we can get some of the court funding issues resolved. Maine is undergoing a complete revision of their entire probate code, and so this is part of their probate code, and they're going to implement the new act. I expect that bill to be introduced any day now. The other states that you see in green, they currently have committees, either a committee of the State Bar Association or a wings group made up of guardian supporters who are considering the act, and with the hopes of introducing a bill in 2019. I should have, North Carolina also has a similar group, and so that one should also be shown in green as this map. But the main takeaway here is that these these guardianship laws are very different. They are very old, and they're not implementing the best practices that you can find in the Uniform Act. So real need for reform. Can we have the next slide, please? Okay, so what are the implications in the states? So first of all, the statute itself, the new Uniform Act is an opportunity to go to your state legislature and say, this is an area of our law that is really outdated, and here's a model that you can take and implement to replace the outdated law. Ideally, we want to try for adoption in full. The various parts of the act work well together, but as we saw in New Mexico, there are some challenges to that. There are some fiscal issues. The courts will be taking on some additional responsibilities. We hope that will be offset, though, also by when people have greater independence, there's less need for involvement by the courts in the first place, and opportunities for people to regain their rights if their condition that caused the guardianship to be implemented in the first place has improved. So we think we can offset at least some of those additional costs, but in some cases we may have to settle for selective adoption. This is a marathon, not a sprint. We'll get it enacted little by little if we have to. But more so than just the legislative change, this is also a vehicle for advocacy. We want to publicize the fact that this act exists, get people talking about its provisions so that people who are involved in the guardianship world, they can recognize, if they are not aware already, that a full guardianship is not always appropriate when you can have something less restrictive like a supported decision-making arrangement where the individual's rights, legal rights, are not completely taken away. It recognizes the Uniform Act recognizes the right for an attorney to obtain a restoration action, or for the person to obtain an attorney to file a restoration action. Just the idea that this exists was, there's a group in North Carolina, we were there a couple of weeks ago, and they were telling us that this has already started, and they are hoping that they can take about 5% of the guardianship cases that are on their books and have the rights restored. We got to hear a success story from somebody who went through that process, which was inspiring. The fact that people can have their rights restored, many people subject to guardianship don't realize that, and so we want to publicize that and hopefully get advocates more involved in kind of some of these legal advances, with or without the legislative change. So next slide, please. There we go. Okay, so the political landscape. The good news about guardianship is this is not a partisan issue. In our polarized times, it can be daunting to get anything enacted in the legislature if it's not supported by the majority party. Guardianship is something that everybody can get behind, and legislators on both sides of the aisle generally will support reforms if they are doable. The gold standard is you want to have a co-sponsors from both parties when you introduce a bill, and this is the type of issue where that's certainly possible. One of the difficulties to get this enacted is that it's not a hot issue. It's not in the news generally, unless there's some sort of crisis. Now, unfortunately, we have had some crises that were in the news in a few select states for this year, over the past year. But we don't want it to get to that point unless there is a crisis. We would like to try to implement reform, and sometimes it's hard just getting the attention of legislators when there are hotter issues, people that are calling, they have constituents who are calling them about and want them to work on. This is a broad issue. It involves a lot of different areas of the law. It involves different branches of the government. You need to get everybody on board. It could be a very long process. It's a long bill, and so those are harder to enact than acts that are only that you can accomplish reform in only a few pages. There's no one-size-fits-all solution. Like it or not, the 50 states have their procedures that have been established over many years, and they're not going to change overnight. Our uniform acts are drafted with that in recognition. There are provisions that can be adapted to fit local state procedures. So, for instance, in some states, it's not the judges who are doing the initial guardianship hearings. Sometimes it's court administrators or clerks who are kind of handling some of the initial work. The act can be adapted to accommodate whatever procedures you have in your state. Diana mentioned early on there's a lack of data. It's difficult to get a law enacted when you can't define with any kind of specificity what the problem is. This was an issue they ran into in New Mexico earlier this year. The courts couldn't tell how many guardianship cases they had that were in force currently. There was no data. They had records of all the cases where guardianships were issued, but many of those people had deceased, had died since the order was issued, or had moved on to another state, and there hadn't been any system to kind of track these cases and keep track of the records. Slowly, we're beginning to see those sorts of systems implemented, but funding, of course, is an issue. I'm sure all of you in your states, courts are moving slowly kind of into the digital age and have electronic records and keeping data on their cases, but it's not happening. It hasn't happened much in the past, especially in the areas of guardianship. Finally, we have to make sure that people are talking to each other, because you can find maybe attorneys who work in this area, or legislators who are interested in this area, who are anxious to debate policy with you and think they understand what's best and what can be implemented. But if you don't have the frontline workers who are actually serving as guardians, especially as public guardians in the state, you don't have the judges who have to issue the guardianship orders, who are listening to the cases, and they see the real world problems, we don't get very far. We find we have to get everybody on board to make sure that everybody understands how their own work in this area is going to be affected. And that kind of leads into the next slide, where we talk about the players who are typically involved in this. More than with most areas of law, it takes a team to enact this Uniform Act. You have to make sure that the courts and the court administrators are on board, because this act changes the way that they operate. There's going to be additional monitoring. There's going to be more individualized consideration of each case. Rather than kind of plenary guardianships. There'll be a greater needs analysis. And so you have to make sure that everybody is on board with this before you can implement it. The guardians and conservators, the people who are working in that industry, again, this is an issue that varies by state. Some states have public guardians who are employees of the state. Others do not. They have private agencies or private individuals who will serve as guardians and contract with the states. Some states don't have any sort of public guardianship at all, and strictly rely on family members. There are senior advocates and child advocates, so the law does cover both. A lot of the news of guardianship has been adult guardianships, but the Uniform Act has always, going back to the original 1969 law, has also covered minors. And the rules for minors are a lot different. Parents have a lot more control over the situation. A guardian typically steps into their shoes and gets many of the same powers that a parent would have to direct the child's life. So the rules are different for children than they are for adults subject to guardianship. We want to get advocates for the developmentally disabled. There are developmentally disabled who kind of cross both of those previous two categories, both children and adults. And when they are 18, there's a procedure, depending on the extent of the disability, where that person might be able to exercise some of the rights as an adult, and shouldn't automatically go from a situation where they legally had no rights as a minor to a situation where they now as an adult still don't have those rights. Finally, we do have our uniform law commissioners who are volunteer attorneys in each state. They're aware of these uniform acts, and they help us work to get them elected or to get them enacted in the legislature. And so we want to put them in touch with all of the other advocates in this area and make sure that everybody is kind of pulling in the same direction when we try to enact this Uniform Act. Can we go to the next slide? State bar associations. I skipped over. I didn't mean to on that previous bullet, but the attorneys who work in this area generally are involved in the state bar association. So the probate trust attorneys, the elder law attorneys, we want to make sure that they're involved as well. So if you think that the law of your state needs reform and you would like to learn more about this new Uniform Act, I would like to talk to you. Please get in touch with us, and we can start helping you work now for enactment in the legislative sessions that start in January 2019. Now's the time you have to kind of start if we want to do that. So we want to gather all the local stakeholders, the local versions of the people who were on the previous slide. It also takes usually a study. So oftentimes a state bar will take the lead on this, or if there's a wings group of guardianship advocates in your state, they can sit down, review the Uniform Act, and then figure out how it needs to change in order to be implemented in your state. So sometimes it's the terminology that needs to be changed, sometimes the court procedures to accommodate local courts. But whatever it is, it's a process, and it doesn't happen overnight. If it's a committee that's doing it, generally it's going to take multiple meetings to get through the act. Sometimes it can take 6 months or a year to get through and draft something that will work for your state. Our office in Chicago, the Uniform Law Commission, is available to consult on those projects and kind of help you through and show you what other states have done, and help you identify, if you have a particular issue, this is how our courts operate. We can help you identify which sections of the act that will affect and need to be changed. So that's something we do regularly, and we're more than happy to consult on those processes. Then the next step, after you have a bill draft that's in the form that you can use, you want to find legislative sponsors, ideally someone from each sponsor and someone who's familiar with this area of the law, someone who wants to work in this area of the law, and is willing to kind of spearhead getting the bill through the legislature. These long bills that affect the way that states operate are difficult, and you're going to, even if you do the best job you can of getting your team together at the beginning, you find people who will show up who learn about it at the last minute and weren't consulted and are going to find issue with it. So I mean, we want to put out those fires to begin with if you can, but you need strong legislative sponsors who can make sure to push this through the legislature as well. So my contact information is there as step one. If you would like to work on reforming the guardianship law in your state, please contact me, and I can start to help you compile a list of the stakeholders in your state and the different groups that you should contact. We would love to work with you on reforming the law by enacting the new Uniform Act. Thank you very much.
Well, and thanks to all of our speakers. We have about 4 or 5 minutes for questions. I will make one comment. The provisions on guardianship of minors are found in Article 2. We could have an entire separate program on that topic, dealing with children's rights and parents' rights. When we initially started the project, we were not focusing on minors, but we did make that a major issue of attention for the last year or so of the drafting process. So if you're interested in children's issues, please take a look at Article 2. We've had a couple questions. Number one, question was raised, can the audience have copies of the slides? And Paula Shapiro of the ABA staff is going to email the slides that we prepared today to all of the people who registered for this program. Please share them with others. They're here as an advocacy tool. And I've also had a conversation on the side with somebody from Louisiana, which has a different legal system. And so offline, we're going to talk about how we would need to modify the act to meet Louisiana's requirements. That's it, at least in terms of the slides and the question box. But we prepared some of our own questions to ask each other. And so one of the questions that we had ourselves was one about guardianship plans, conservatorship plans, and I think, Nina, you're probably the one to answer this. When are they required, and essentially what do you put in those plans?
So the idea outset of the guardianship relationship, the conservatorship relationship, the guardian or the conservator is to create a plan for how they will carry out their duties. And then those need to be revised if certain major events happen. Otherwise, they don't have to be revised at a particular cycle, but rather when particular events occur. So if the person's needs change, then you need a new plan. Whereas a report is a regular reoccurrence, regardless of whether there has been a major change. Do you want to speak more about that, David?
No, let me make one final comment, because we have 1 minute left. There's much more in the Uniform Act that we have not covered today. The draft of the Act is available on the Uniform Law Commission website. And Ben, I believe that's in the materials somewhere for the program. And so you'll find a complete draft of the act. You'll also find the advocacy one-pagers, which I think will help you in the enactment process. And keep in mind that this legislative process can take considerable time. So it is not surprising sometimes, having myself been involved in these efforts in 2 different states, that it does take more than a year. So you need to be patient, and it's very, very important that you have a careful study, and at the study, get all of the different interest groups at the table to try to reach a consensus. It's now 1 o'clock. Paula, I think we're done. Are you there?
So for those of you, just to reiterate, the contact information for everyone who was on this panel is on your screen, and I think it's fair to say we would all welcome the opportunity to talk with those of you who are interested in knowing more about the Act. Obviously, Ben is your point person for everything legislative enactment, but really all of us are here as resources.
Well, thank you to everyone.
Thank you.
Thank you for joining.
Thank you.
Thank you.